Two cases, one courtroom, and a judge facing two difficult decisions. In the next 15 minutes, you'll watch two young parents stand before the court, holding on to probation as their final opportunity. Both are accused of making the same serious mistake, and both must answer for their actions. As the hearing unfolds, the judge carefully examines the facts, the choices that were made, and whether another opportunity. Will the court decide that rehabilitation is still possible? Or will there be more serious legal consequences? Stay with us, because the judge's reasoning offers a fascinating look at how accountability and second chances are balanced in the courtroom. By the end, you'll be asking yourself, if you're making the decision, what would you have done? Let's get into it.
That's all.
All right, Mr. Coleman.
I'll be brief, Judge. The defendant is here through his own actions, and if that has a negative impact on his licensing, then it's because of his own fault. The state's recommendation is based on the defendant's criminal history and the nature of the offense, the nature of leaving this infant child in a car that reeked of marijuana. And that's really all I ask.
If I can just respond briefly, it seems like that obviously he's got to support the family, and that's in the child's interest that he maintain employment, that he's able to support the family. So,
Do you have regular drug testing with your job?
Yes, ma'am.
Would you pass a test today?
No, ma'am.
Why not?
We're going to get probation, so we're going to stop. We stop last Friday.
So you're on.
Let's just sit with that for a second. Yep. The judge asked a simple yes or no question. Would you pass a drug test today? And the answer was no. Not I haven't smoked in months. Not I'm clean. He straight up admits he stopped last Friday, days before walking into a courtroom that could send him to prison. That's not quitting for your kid, that's quitting for your court date, and judges see through that instantly. This is the moment his entire credibility problem starts, because if you can't be honest about something this basic, why should the court trust you with anything bigger, like custody?
what would you be doing?
Marijuana.
It's not that's it, right? It's just not that's it. You have how many prior marijuana related offenses? There was marijuana smell with the baby in the car, with you and your baby's mother. You're here thinking, yep, she's just going to give me probation, so we'll start a week before. Stop smoking when you shouldn't have been smoking the whole time. Like, that is the craziest thought process. So all this talk about your job and how important it is, what if they drug test you? It must not be that important to you.
It is.
It's not. Clearly, it's not. Taking care of your family is clearly not a priority if you're still smoking marijuana, knowing that you could lose your job, knowing that you could go to prison. Then there's something wrong with how you're thinking. I'm not sure what I'm going to do. Have a seat in the jury box and I'll think about it.
Here's the legal chess move most viewers miss. The judge just sent the defendant to sit in the jury box, not the holding cell, while she calls up the second case. That's a deliberate power play. She's not ruling yet. She's making him sit there in silence, watching what happens to someone else facing the exact same problem, or she decides his fate. In courtrooms, that pause is often more powerful than any lecture. It signals, I control the timeline here, not you. Keep watching, because the next defendant is about to walk into the same trap.
I'm going to hold that one for a few minutes. I'll think about him and take care of it in just a minute. Because it's the same issue. He said they did quit a week ago. Miss Allen, come have a seat up here in the jury box as well.
I'm going to stand back next to you.
And not next to each other. Okay, so Mr. Casey, again, we've already gone over what you were here for, what you pled guilty to. You've told me, I'm not going to worry about getting a test, that you would test positive for smoking marijuana after all of the things that I've read and seen in your pre-sentence report. I am willing to follow this probation, but there are going to be some conditions that were not anticipated today. And I want you to know, as I'm saying what those are, it's the only way I'm going to follow the agreement and give you probation. So here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. I am going to give you the opportunity on a deferred probation because I want you to be able to work and provide. So I'm going to defer all proceedings and place you on probation for a period of 5 years. I'm going to order a fine in the amount of $1,000. I'm also going to order that you enter and successfully complete the ISF program, the cognitive track of ISF. That means you're going into custody today. It's a 90-day program that is to help you make better thinking decisions. And when you are released, you are going to be required to enter and successfully complete the JCDI program for drug treatment, because obviously you need help with 2 different things in order to be successful in the future.
Okay, let's break down what actually just happened. Because deferred probation sounds like a slap on the wrist, it is not. Deferred adjudication means the judge never enters a formal guilty finding on his record as long as he complies. That's huge because it means no felony conviction hanging over him for life, if he succeeds. But look at the price tag, a Ling fine, a mandatory Courier's Day cognitive intervention program starting today, meaning he's taken into custody right now, followed by a drug treatment program on release. 5 years of probation. 1 violation, and that deferred deal evaporates. He's automatically guilty and facing up to 2 years in prison. This isn't leniency. It's a loaded second chance.
This is what I'm doing, period.
Please.
Nope, there's no please. Same thing's happening to her. So
What?
y'all need to stop and you need to calm down, because y'all are the ones that made the decisions that you made that make absolutely zero sense. And so the only way that I feel comfortable with you being out on probation and possibly getting your child back is that you go through and get some kind of treatment so that you make better decisions, and so that you'll stop smoking marijuana a week before court. Nope, there's no raising your hand. I'm not going. Well, then you'll have to get another one when you get out. And I hate that for you. But listen, stop talking or things could be even worse. Listen, I'm not doing this to you. Y'all did this to yourself. You did this to yourself. I didn't do this. So there's no, I'm sorry for doing this to you. I'm giving you what I think is your best possible situation to be able to be successful. All right. So again, you're ordered to the ISO. And here's the thing. You've got the deferred probation. This is a program to help you do better. When you get out, you're still on a deferred probation. You don't have a felony conviction on your record. You're going to be able to be successful. And if you are, the case gets dismissed at the end and you don't have the felony conviction. If you violate any condition of probation, then you're going to be back in court and you'll be found guilty and you'll be going to prison for up to 2 years. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You can go back with the bailiff. So you're Chelsea Allen, and Miss Allen, you were previously in court, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child. I've received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Judge.
I have,
Are there any additions or corrections?
No mistake.
So you went through an outpatient substance abuse treatment just last year, right? And you did that through Spindletop, and you're still smoking marijuana a week before court.
Are you smoking marijuana? Did you smoke marijuana a week ago? Yes, sir.
Yes. So based on that, and based on the fact that you've had outpatient treatment and you're smoking marijuana a week before court.
She completed an outpatient recovery program last year. Yet, she's back in the same courtroom, facing a very similar situation. She also acknowledges using an illegal substance just 1 week before her sentencing hearing. This is no longer being viewed as a one-time lapse in judgment. Instead, it raises questions about whether the previous intervention led to lasting change. That's why the judge's tone becomes much more serious. The focus isn't only on the recent conduct, it's on whether the support and opportunities already provided have made a real difference. In your opinion, are outpatient recovery programs enough in situations like this, or should the courts consider a more structured approach? Let us know your thoughts in the comments. Deferred.
Obviously, that gives me concern, and I'm going to any other.
I think the court will address this with the way you're fashioning this probation, but she did minimize, and I highlighted, certain portions.
I did too.
She kind of minimized her responsibility for this officer.
But she does have obviously some mental health issues that she's followed through with this mental health. And at least she's honest here.
Well, and here's the thing. I mean, you can get some points for being honest, but you also have to make better decisions. And when you've already gone through treatment and you're waiting for a felony court and you're still making those bad decisions, then the only way for me to have any sense of responsibility, I think, to what I have to do and to the community and for your child and for you to be successful is to get you more intensive help than what you've already had. So I'm sorry.
You're going to be homeless.
Listen, I appreciate what y'all are saying, but I didn't get, I did not get you here. I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. However, I'm going to follow the agreement and defer all proceedings and place you on probation for a period of 5 years. You're ordered to pay that $1,000 fine, and you're ordered to
Yes, Your Honor, my thinking was that perhaps the court's concerns could be addressed in action.
I'm considering something a little bit different for Miss Allen. I know that probably doesn't help a lot financially, but just based on the situation before with Spinal Top, just take a breath.
We do have that here.
I know. Take a breath. I mean, do you understand? Do you understand why I am where I am? And how irresponsible and how ridiculous the decision was to smoke. What?
Yes, I would never do this again.
Well, I mean, you would.
Leave him, I will.
Well, it's not a matter of y'all leaving each other. It's a matter of you making this, and it may be if that's what makes you make better decisions, right? So if you have, hang on, listen to me, all right? If you are feeling pressure to make decisions and to smoke and these decisions that make no sense, then you have to do at this point what's right for you, because you, regardless of what happens to him, are looking at going to prison for making those decisions. Whether you feel pressure for them, whether you make them on your own, it's time for you to take that personal responsibility and do what's best for you and your child that you don't even have right now, and that you're not going to get if you keep making these bad decisions, right?
This is genuinely one of the more human moments in the whole hearing. The judge isn't just reciting conditions here. She's directly telling Chelsea to stop making decisions based on pressure from her partner and start making decisions for herself and her child. That's a judge stepping slightly outside the strict legal script to address something deeper, a possible pattern of one partner's choices dragging the other one down. It raises a bigger question this case doesn't fully answer. How much should personal relationships factor into individual accountability in the eyes of the law? Should Chelsea be judged separately from Casey's choices, or are they a package deal here? What do you think? So let's recap what just happened in this courtroom. Two company defendants, both pleading guilty to endangering their infant child after marijuana was found in the vehicle, and both walking in already knowing they'd fail a drug test that same day. The judge gave both deferred probation, meaning no felony conviction if they comply, but stacked it with real teeth, AE, ling fine each, mandatory treatment programs, one going straight into a Coder's Day custody-based cognitive program, and any path back to their child running through strict supervised conditions monitored by both the court and CPS. The bigger takeaway here is how differently the justice system can treat repeat noncompliance versus a first documented failure, and how much weight a judge puts on whether someone takes personal responsibility versus blaming circumstances. This case is a real look at how deferred probation works, why courts use it, and just how thin the line is between a second chance and a prison sentence. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.